What is a J-1 visa?
J-1 visa is when foreigners are coming to the United States on a temporary basis, either to come and pursue education, research work, or to participate in a program. But every participant in a J-1 visa must go back to their home country for at least 2 years at the end of the J-1 program. It's a mandatory requirement, although there are few exceptions.
On what grounds can somebody apply for a waiver of a J-1 two-year foreign residency requirement?
Yes, as I stated earlier, there are exceptions to the 2-year foreign residency requirement. An applicant may apply for a waiver. There are several grounds for applying for a waiver, but the most common is what we call no objection letter. If the applicant is able to get a no objection statement from his or her home country, then they can use that no objection statement to apply for a waiver. Another ground, where an agency of the United States, for example, where the applicant participated in a J-1 program, if the agency of the United States, if they are interested in this particular applicant, they on their own can apply for a waiver from the United States government on behalf of this applicant. Another ground that someone can apply for a waiver is if going back to the home country we expose this person to danger. This will be the same requirement as asylum. Somebody whose life will be in danger, or if they could be killed or persecuted upon return to their home country, they can use that as a basis for the application of the waiver of the J-1 two-year foreign residency requirement. In addition, if the applicant have a qualifying relative means a U.S. citizen or permanent resident, spouse or minor children who will suffer hardship if they have to go back to their home country, then they can use this as a basis to apply for a waiver of the 2-year foreign residency requirement. I must clarify this because I don't want to be misinterpreted or misunderstood. Now, this waiver based on hardship to a spouse or a minor child of a U.S. citizen, if that waiver is granted, it is not a basis for adjustment. The applicant still cannot adjust status. So if someone is married to a U.S. citizen and then the person is on J-1, at the end of the program, the person is thinking that, oh, for as long as I can prove hardship to my United States citizen spouse, I will be able to adjust my status. That is not possible. This waiver is just to prevent this person from going back home for those 2 years, at least on a temporary basis. It does not lead to adjustment. Now, there's another way to apply for this waiver. This is called Conrad 30 program. Basically, it is for people in healthcare field, healthcare professionals. So there are some areas in the United States that are classified as underserved. If this healthcare professional agree to work in these underserved areas, they can use that as a basis to apply for the waiver. However, for them to agree to work in this underserved area, there are some conditions. For example, upon the approval of the waiver, they must resume employment within 90 days. It is mandatory. Secondly, they must sign an agreement or sign a contract to work in that underserved area for a minimum of 3 years. So they cannot just get a waiver and then maybe work for a year or two and then say, you know what, I'm moving into the city. No, they can't do that. Minimum of 3 years, they have to work for that employer. So on those grounds, someone can apply for a waiver of the 2-year foreign residency requirement. Thank you for watching. We appreciate it. Because our desire is to educate as many people as possible, we have decided to go live effective January 2023 so that we'll be able to answer people's specific questions. So please watch out for our live podcast effective January 2023. Thank you.